All right, so you're Raquel Glover, and this is cause number 24 DCCR 0232. Mr. Glover's case was set for trial a couple of weeks ago. We were about to start with jury selection. Mr. Himmler filed a motion to quash the indictment based on some relatively new cases that have come down from the Fifth Circuit as well now from. All right, so you're Raquel Glover, and this is cause number 24 DCCR 0232. Mr. Glover's case was set for trial a couple of weeks ago. We were about to start with jury selection. Mr. Himmler filed a motion to quash the indictment based on some relatively new cases that have come down from the Fifth Circuit as well now from the Supreme Court with regard to underlying offenses on unlawful possession of a firearm by a felon. I have done a substantial amount of reading of those cases and reviewing all of that since the last court date. I know your position, obviously, Mr. Himmler, Mr. Nichols. What is the state's position?
Judge, after looking at those myself, I think we're in the Fifth Circuit case dealt with the underlying felony of being a simple possession of drugs. The Supreme Court ruling wasn't so much felon possession of firearm, but a firearm in the possession of a firearm by a drug user. So that was kind of the main theme under all those cases was simple possession, simple drug use does not equal dangerousness. In this instance, Mr. Glover's prior is for child endangerment. And while it is some years ago, on its face, that is reasonable to deduce that's a dangerous prior felony. He also has the intervening felon possession of a firearm in the years since that original conviction. So I think in this instance, the state can make a very clear argument that he's shown a history of dangerousness and that the prohibition on possessing a firearm by a felon should apply and the motion to quash should be denied.
All right, thank you. Anything else to follow up?
Other than just, I think the inquiry is dangerousness, and obviously drug cases are a subset of dangerousness, lack of dangerousness, but I don't think the ruling is limited simply to drug cases. I think the court's research probably reflects that. The question is whether the underlying felony conviction of endangering a child rises to that level of dangerousness, so as to preclude his ownership of firearms or possession of firearms. I would just note that at the time he pled to that, there was no DWI child passenger statute. And I think had that statute been available, that's probably what he would have pled to. And then you obviously wouldn't have the endangering language and the conviction itself. So that is something that I would ask the court just to note that should the case just not to take notice of the fact that if the case were indicted today, it probably would not have been pled as an endangering child, DWI child passenger, and whether DWI child passenger cases are inherently dangerous, I guess, is another inquiry as well.
So there's nothing at this time in these newer line of cases that is specific with regard to any other real underlying type of offense other than possession of a controlled substance or possession of a drug of some sort. And I'm not going to start going down the road, I think, of making those decisions unless it is real clear. I think for whatever reason that underlying offense should not be included. And so I am going to deny the motion to quash, and we will get this case set back on the trial docket as quickly as we possibly can.
I think it's currently, it has a trial.
Is it still already? Okay, it is. All right. And just also part of that finding that I'm making is based on the actual facts of the underlying case, regardless of whether or not it's an endangering a child or nowadays a driving while intoxicated with a child passenger. I would think regardless, that's the same, that the facts of this case as reviewed with a young, I think it was a 9-month-old or 8-month-old sitting in the lap of the passenger in the front seat of the car. I think that in and of itself is dangerous, whether it's a DWI or an endangering a child, either way. So that is the basis of my finding. So we will move forward with trial at that next court date.
Sure.
All right.
Thank you.
You can, you're free to go, sir. I don't have an order. If someone would prepare an order, please.
Yes.